rise if able.
Yes, Mr. Rudd, you're going to take us to some authorities, I think.
I was just a limited number just to assist. The purpose of this is to illustrate how what I say is the appropriate way to interpreting a permission. The first one is one we've already looked at. It's the Wall and Winchester Authority.
Yes.
It's page 296, and in particular it's paragraph 22.
Yes. Yes.
So I made reference to this proposition that when considering a planning permission, the description of development tells you what you can do and the conditions of what you can't do. And taking away the condition doesn't change the description of development. The description still provides for, say, X and Y. It doesn't provide for Z. Z might not be unlawful unless it's a material change of use. So what Lord Justice Sullivan does, obviously in the overall context, I'd ask you to have consideration to paragraphs 19 to 22, 19 to 23, which deals with the wider interpretive principles relating to the matters we've already considered. But in
already looked at that.
yeah, I'm not going. I'm just yes. 22 is just the specific one here in terms of the second limb.
Okay. Which bit of 22?
So the last three lines before the quote. So it says, the position was accurately summarised by Hickenbotham J in paragraph 50 of his judgment in Cotswold Grange Country Park, and this is what I want to place reliance on. The grant identifies what can be done, what is permitted, so far as use of land is concerned, whereas conditions identify what cannot be done, what is forbidden. Simply because something is expressly permitted in the grant does not mean that everything else is prohibited. Unless what is proposed is a material change of use for which planning permission is required, because such a change is caught by the definition of development generally. The only things which are effectively prohibited by grants of planning permission are those things which are the subject of a condition. A breach condition being an enforceable breach of planning control.
Yes.
Which that sets out the important distinction between the description of development, which will, looking at the earlier paragraphs, contains functional matters of functional significance, so the description and the conditions. And in this case, because I say we're looking at a breach of condition, it's removing what is prohibited, but what is permitted is still governed by the wording in the description of development itself, and that's the proposition that Lord Justice Sullivan engaged with in this case, in the Wall and Winchester case, but it was formulated by Mr. Justice Hickenbotham in Cotswold.
No, it's not. With respect, that's not the proposition he's engaged with at all. The proposition with which he's engaged in this case is, first of all, if you've got a permitted use for the land, then the question is, has something that has been done an infringement of that permission or not? If it amounts to a material change of use and you've not got any inherent restrictions in the way in which the use is described, as of the kind that we saw with the travelling caravans and so on, then absent any condition, you can do it. So there are two layers of prohibition. One is in the actual formulation of the permission, and the other is by the means of imposing conditions on it. But what this is not authority for is a proposition that if you are permitted to do something which would otherwise be a breach of condition, there is no lawful use.
No, but that goes back to how the certificate is interpreted. and whether the certificate is a use certificate or a breach of condition certificate.
Well, I know you say that. I mean, I'm waiting to see the authority of that proposition.
Well, I'm trying to set out these authorities as to the global context about what conditions act as the purpose of condition and the purpose of the description, because there are two different purposes.
Yes.
So,
Just for my benefit, if I put caravans on my land, that would be a material development, would it?
material change of use,
Yes.
quite likely, almost certainly.
Requiring.
Yeah.
Okay. Thank you.
Without going into the niceties of permitted developments, etc., if you have a field that is an agricultural field and you place caravans on it, it's likely to be material change of use.
Yeah.
It's not operational development. It's a change of use that needs planning permission.
Yes. Thank you.
If I could ask you now to turn to page 339. And this is the case of Frederick Adams from the Secretary of State for Housing, Community and Local Government, again before Mrs. Justice Laing. And there's a number of paragraphs in here that I will ask you to have regard to in due course. And I'll emphasise the parts of those paragraphs. So firstly, paragraph 1 to 25, on page 345. This is what the court helpfully, usefully summarises the process and the relevant provisions when making an application that apply when making an application for a lawful development certificate. And
Another touring caravans case.
it is, yeah. It's a case where it related to a certificate that had been granted, where the terms of the certificate were specific, but there were references in the notes of the elsewhere in the certificate to another planning permission. And the applicant in this case, when the application was made, sought to rely on the first schedule only. So what was declared as being lawful in the first schedule. And what Mrs. Justice Laing said is that's not right. You can't just hone down like that. You have to look at the certificate as a whole. And although the notes in certificates have no statutory effect, because there is no provision to put notes on the certificate, they still can't be ignored because you have to read the certificate as a whole. And in those notes, because there was reference to another permission, a historical planning permission, the conditions from that planning permission were found to still follow through, even though they would appear to be in conflict with the description of development in the first schedule. So this Adams is the proposition for having to look at the certificate as a whole. 21 to 25 sets out the process, if you like, just the practical process in light of the statute and the development order, the DMPO, what needs to be provided. Paragraph 35 to 37. Obviously, I'm not going to read through those, but what the court is saying there is dealing with the relevance of information elsewhere in the certificate other than in the first schedule. And that information elsewhere, even though it had no statutory effect because it was in notes rather than as part of the reasoning, still had to be taken into account. So see paragraph 38 there. Court is saying, however, in my view, it's a valid criticism. The drafting of the certificate, but more detail, in particular references to the extant planning permissions and the conditions attached to it, should have been included in the first schedule for clarity and the avoidance of doubt. But faced with the task of interpreting an imperfect document, I consider that the inspector was entitled to read it as a whole and to take into account the text in the body of the certificate, including notes, has no statutory effect, as well as the first and second schedules. And I say that that equally applies to taking into account when reading a certificate the reasons for granting the certificate, because the reasons are a statutory requirement. Without those in the certificate is defective. Section 191 requires them to be there.
So you say the reasons are a fortiori, the reasoning by Mrs. Justice Laing in this
Yeah.
case.
And the reason in this case is expressly relates to a breach condition. So they can't be ignored, they can't be disregarded, they're part and parcel of what was granted.
Well, they're not part and parcel of what is granted. They're the reason why it was granted.
Yes, but
You're actually trying to elevate the reasons into what the grant is. The grant is use for residential purposes. The reasons for that grant are set out on the face of the certificate as they must be, but the reasons are not the grant. They are reasons. Self-evidently, they're reasons.
yes, which are required to be there by statute.
Yes.
But
You read the whole document as a whole, but you cannot interpret reasons as being the grant or conditioning the grant.
I'm not trying to do that, lady. I'm saying you can't set them to one side. That the whole thing must be read as a whole.
Yes.
So the reasons may explain the grant
Yes.
or elucidate it.
Or inform
Yeah.
the grant.
Okay.
But what they can't
They're
be.
stating why it is that somebody is, why it is that the use is now regarded as lawful, because that's the purpose for which the statute requires them to be put into the certificate.
Yeah, why the contents of the first schedule, why the contents of the first schedule are being declared as being lawful.
Yes, it provides an explanation for the declaration of lawful use.
Yes,
Yes.
but you've got to read them all together. And the declaration in this case relates to a breach condition, not a change of use. When taken,
That begs the question.
well, I understand that, lady, but when read as a whole, which one in my submission one must, it is not clear cut that the 191 certificate is a use certificate. Even if it is, it's a use for houseboats, nothing more. So the application clearly was made on the basis of a breach condition, and in my submission it was granted on the basis of breach condition, because there's nothing in the officer's report that makes reference to a use.
Are we entitled to look at the officer's report if it's not ambiguous?
If the certificate is not ambiguous, I'm going to have to accept that you probably aren't. I don't think you get through the gateway, Mr. Justice Keen's provisions in the Ashford case.
Okay.
You look at the application and plans, etc., but not the officer's report. But I obviously I have to place reliance on the fact that I say that the conditions, the reasons, and the first schedule, there's an element, if nothing else, of ambiguity between the two. And the only other document that we can access that assists us with trying to resolve that is the officer's report. But lady, yes, if you find there's no ambiguity in it, then the gateway for the report's not open. I accept that.
Right.
And then one final authority at this stage. It's page 492, please. Sorry, I should have said just for your note. In the Adams case, I place reliance on paragraphs 35 to 37 in terms of the importance of reasons or additions, and then 38 to 39, where the court says you've got to read the document as a whole.
Yes.
And 492.
Barton Park.
It is Barton Park Estates, yeah.
Yeah.
Sorry, the case commences at page 480, but I just want to look at paragraph, place reliance on paragraph 28.
Well, we're back to the original interpretation of the original grant here, aren't we?
In a way, but it's what 28 is looking at as the effect of, I say, the effect of removing a condition on the description of development. So
That's not what Sir Keith is actually addressing here.
well, it's dealing with the court's dealing with the conclusions that can be drawn from the interpretive principles. It says over page paragraph 27. First, the reasonable reader referred to by Lord Hodge and Trump would not say a planning permission be granted for a caravan site, etc. He goes on, and at 28, secondly, the absence of conditions specifically restricting the number of residential caravans on the site does not have the effect of altering the description of development by the grant in the grant itself. It does not change what the planning permission is actually for. The permission is for the development described in the best brief particulars, restricted by the conditions limiting the occupation and use of that development. It is not for some other proposal formulated in a different terms from the grant. But I place reliance on that as an authority that if you going back to what Mr. Justice Heckingbottom said in Cotswold Grange, where you have the description set out what you can do, the condition controls that. If you remove a condition from a planning permission, it doesn't alter the description of development. The description of development is still as it is.
It still controls what you do, or it doesn't control it in quite the same way, but it doesn't affect the original grant. So if you had 5 conditions on a grant of planning permission, one of those conditions is breached for 10 years, it doesn't mean that the other 4 conditions don't bite. So far, so trite.
Yes, but
where does that get you?
That's by action of statute. What I'm saying in this case is if and I accept you don't appear to be with me on this, if the certificate is a condition, is a certificate that declares the condition to be unenforceable, that is what the certificate provides for. The grant of that certificate cannot alter the description of development. So the description of development, the holiday limitation in the description of development remains.
Well, you say 2 elements remain, the holiday plus the fact that it refers to houseboat.
But it's the houseboat element, which is obviously my main
I'm
argument.
struggling to understand why the holiday limitation remains in relation to the particular piece of land where there's a certificate of lawful use. I follow the houseboat limitation point, that I've got completely. But once you've got a certificate of lawful user that removes that condition effectively and says you can use it for purposes other than a holiday, then how can the holiday condition still remain?
Because it's still in a description of development, and the description of development hasn't been altered. So if I apply to, if I provide an example, if I have a planning permission that says 10 holiday caravans,
Yes.
and there's a condition that says only 10 caravans,
Yes.
if I apply to remove the condition that says 10 holiday caravans, I'm still left with the 10 in the permission in the description of development. And there will be an argument.
You'd be able to have 11 or 12 if you take the condition off.
Well, that would depend on whether 11 or 12 would be a material change of use or not. But the permission itself, and this is the point of the Cotswold Grange quote, the permission says what it provides for. So it doesn't provide for any more. That doesn't mean that any more it would be prohibited. It would only be prohibited by condition. You would have to then look at whether adding more caravans. And yeah, this is quite a common approach, where you've got a planning permission that says planning permission for 5 caravans, and there's no condition. And a landowner comes along and says, well, I want 10 caravans, please, and puts in an application under section 192 for proposed use. The argument is, well, you don't have planning permission for 10 caravans, it's not provided for. So the examination that has to be undertaken is, would that amount to a material change of use by adding these additional caravans to something that a permission that is only described in terms of 5 caravans?
Well, you'd be asking for permission to extend it to 10.
Yes, but under the existing use, not a fresh permission.
Well,
So-
that presupposes that you've already got that there's a limit by the description.
Yeah.
So if the description is limited to touring caravans or static caravans or whatever it may be, then I see where I sort of see where you're coming from. But if you're wrong about if you're right on the point about houseboats and the description is limited to houseboats, then you say that the removal of a condition in relation to holiday homes for houseboats doesn't affect that. And I follow that. But if you're wrong on your first point, then where does it get you?
If I'm wrong on the first point, and your ladyship finds that the 191 certificate is for a use,
Yes.
i.e. new use, then I must fail.
Right.
If I'm wrong on the first point, in that you find that the houseboat is a caravan. My point is that, setting aside the first point, I say that the certificate, properly interpreted, is not a use certificate. It provides for a breach of a declaration that the condition limiting the use is no longer enforceable. And the effect of that is to strike that condition out of the 1998 permission. It doesn't remove.
Let me. I want to take a note of this because I want to understand the argument. So don't go too fast, please. So it's a declaration that the condition is no longer enforceable. Yes.
But it doesn't change the description of development. The description of development still provides for, it's not a limitation, it provides only for a holiday use. So we have to be careful looking at limitations, claim limitations in the description of development.
What was the point of having a condition in the first place if the description is limited in that way?
Because it's not limited. This is what I'm saying. You've got to be careful
If the
about.
original grant only allows you to put houseboats for holiday use, and that's inherent in the description,
Yeah.
you don't need a specific condition saying you can't use it for any other purpose.
Well, with respect, you do, because the long line of cases of I'm Your Man and Elton Cagnac and Wilson and everything that's set out in the wall and that says if you want to limit, restrict the planning permission in a certain way, it should be done by condition. And that is the point of the formulation that the description of development says what you can do and nothing more. It doesn't mean, as Lord Justice Sullivan said, that doing more would be unlawful. That is an examination that has to be had to see whether it would amount to material change of use. But it's not constrained. So you have a description that says you can do this with your land, and only this, and a condition that says this is how we're going to control that use.
Yes.
So this is all you can do. If you take the condition away, you still have the description that says you can do this, but doing more wouldn't be a breach of condition, but it might not be provided for by the planning permission. You would have to carry out the material change of use assessment.
In theory, I can see that, but I can't at the moment see how that works here.
Because in my submission, the certificate that's granted is a breach of condition certificate. So it takes out the limitation.
That begs the question.
Well,
it begs the question because, and this is why I'm struggling. I'm not being deliberately difficult. I'm trying to struggle to understand how it applies in this context. The condition specifically limits the use of the houseboats to holiday use. Once you take that out, you say it's inherent in the original grant that it's limited to holiday use anyhow. Do you?
I'm hesitant to use the word limit because this is what the applicant, the appellant, fell foul of in the Wall case. It's not a limitation in the description of development. It is a functional. It's a functional part of the description that sets out what's provided for. If you do something different or something more,
this is just angels on a pinhead stuff. With respect, I mean, there is a constraint on what you are allowed to do, or there is a scope of the permission as to what you are to do. And
Yeah.
as I understand it, you say that that scope does not extend to residential use.
No, that's right.
And you say that the effect of taking away an inhibition on using it for that purpose does not confer a grant for residential use.
Not
Is
if it's
that the point?
yeah, not if it's a breach of condition declaration. If it's a use declaration, as in under 1911A, then it does.
Is there any authority directly in point that draws this distinction between a breach of use condition and a change of use and a taking away conditions?
Not that I'm aware of, your Lordship. It's about interpreting the certificate as a whole.
So there is no direct authority for the proposition that you're putting forward, that there is a material distinction between which route of user you go for.
No, because it's in the statute.
Right.
And the statute sets out 3 distinct, clear, separate routes
Right.
for a declaration of lawfulness. I say the declaration of lawfulness in this case is in respect of a breach of condition, which has to leave the parent planning permission, if I can put it that way, in place. Declaration for a lawfulness of a use, it doesn't matter what the existing planning permission is for, other than to set a baseline. If the use is different and it's existed for 10 years, then it's lawful. But the point I'm making, relying upon cases of Wall and Adams and Barton Park, is the need, and when one goes back and looks at the case of Adams, you'll see how Mrs. Justice Laing considered the cases of Broxbourne onwards, about the need for certainty in interpreting certificates. They must be taken to do what they say they do, and not something else.
Can I just ask one point? If you were wrong about the certificate and it was a change of use,
Yeah.
I think I understood your argument to be effectively that the 2014 document is then a sort of self-standing permission. Is that right?
It is.
What my question leads to is, what does that do to your first limb of your appeal?
Well, you still have to look at whether what the permission provides for, because what the 2014 certificate is doing is saying you've got an activity that's taking place on the land, and if the court finds that the certificate relates to that to a use and not a breach of condition, you still need to consider what that use is, because the certificate doesn't say.
You haven't got, it isn't, having sort of divorced it from the 98 permission, you haven't got your same reference to houseboat.
Well,
I know there is a reference to a houseboat, but actually it's under a label of what the land is.
well, it's in the second schedule, which is absolutely
That's a
key.
description of the land, so
Yeah.
it's inaccurate on any basis because the houseboat isn't the land. It must describe the address, location of the land. That's
Yeah.
what the second schedule is.
But the difficulty with that approach is, what then does the certificate provide for? Because it just says a
Use of
use.
the land
That piece
for
of land.
residential purposes. That's
Exactly.
what it provides for.
It says certificate of lawful use as existing.
Yes, but
for
it
occupation
doesn't,
as a sole
but
residence.
it doesn't have the references on which you've been relying in the 1998 permission to houseboats.
Well, that then begs the question, what is the residential use that's allowed? There has to be an element of common sense applied to this. What if we go down the route of finding that it's a use and not a breach of condition, it has to be the use of the houseboats that were there, were granted planning permission, have remained there and are still there now, which are the subject of the Mobile Home Act agreement application, and is referred to Houseboat 8. So it's very specific. It's Houseboat 8, West Pontoon, and the plan is specific to that. So it has to relate to the use of the houseboat. It can't relate to the use of anything else.
It's got to relate to the use of the land, because it's not,
Yeah.
the houseboat isn't the land. It's, my lady's point is that unlike the concrete block, that you pointed out, the pontoon isn't part of the land, it's part of the houseboat. So it can't relate to the use of the pontoon. It's the use of the land for some purpose, and the purpose is residential.
Well, and then we go back again to the reasons. Because it has to be read as a whole. And the reason says, on the balance probabilities, the evidence submitted with the application has demonstrated that the accommodation, so we're dealing with the residential use, is the residential use of the accommodation, which on everybody's understanding is houseboat 8 and land associated with it. It's not a carte blanche certificate for use of land for residential purposes. That's not been suggested by anybody, and that would be extending the interpretation of the certificate in my submission to not a credible extent.
But it says as existing.
Yeah, which is the houseboat.
Yeah.
But it also refers to accommodation. So in my submission, this certificate, however, whatever route it is going down, whether it's a breach condition or a use, still only refers to the use that's set out in the plan, as it must, which is the houseboat and the land associated with it, or the part of the marina associated with it.
So you would make the same points as you made before, that the permission is not, for example, to use a caravan half sunk in the water.
No, and the tribunal accept that. You can't. The permission says houseboat. If it was right that the permission provided for allowed for the caravan, because that the Willoughby caravan, because that's the only element of the structure that is a caravan. Nobody's suggesting that the houseboat itself is the caravan, and the tribunal found that it's not. If the marina was drained, you could not put the caravan on the land, because there's no permission to put that caravan on the land. The permission is to put the houseboat on the land. And going back to something that was said earlier, yes, it's the caravan that's lived in, but the caravan can't be lived in without the float, because it can't be accessed. It can't be used. It can't be accessed. The two are integral to each other. One can't live on the float. One is not going to live on the float alone, presumably. But equally, one can't live in the caravan alone. They both have to be lived in together as one integral, indivisible unit. And there's no planning permission that it provides for either of any of the divisible bits, if you like, to be placed on land. The permission is for the houseboat to be placed on land, the use of land. So even if I'm wrong on the certificate approach, that this is a certificate that is for use of the accommodation, I still go back to the point that the accommodation isn't a caravan. The accommodation is a houseboat. As referred to in the second schedule, which is a statutory requirement, houseboat 8.
Right, you were going to take us to another authority, I think?
Um,
Is there any other part of Barton Park that you want to take
No,
us
it's
to?
just that one section about how one should treat the removal of or the failure to impose a condition. I one eye on the clock. I just ask your ladyship to have regard to, and I'm not going to take you to it, just paragraph 62 of the Upper Tribunal decision, where they address the relevance or otherwise, actually they dismiss the relevance of the condition, the reasons given in the certificate. I'm just I'm not again with one eye on the clock. I'd like your ladyship to have regard to the authority of Breckland District Council, page 329 of the bundle. I just, in due course, ask you to look at paragraphs 46 through to 51. They are paragraphs which emphasise the importance of A, not seeking to go behind the certificate that's been granted, looking at the certificate as a whole and interpreting it in the context that it was granted, not looking to go back and re-investigate what the council were trying to do in this case, the local planning authority. The certificate had been granted for a caravan and camping site, and what the local authority were trying to do is go back and look at that certificate and say, well, actually, it's a touring caravan site. So it's not a camping site. And Mrs. Justice Laing said that you just, once the certificate's granted, the use set out, the detail set out in that, it'd be conclusively presumed to be lawful. And you can't then re-examine it and look at it again. And that's relying on the long-held principles, as Mrs. Justice Laing sets out, paragraph 49 onwards in the case of Broxbourne District Council. Just, I do say that this is just wrapping it up. This is a certificate that, when interpreted in the round and on the whole, is a certificate granted subject to section 1911C. It's a breach condition certificate, not a use. The effect of that is to leave the holiday element in the description in place, which precludes the site being a protected site for that reason. But even if I'm wrong on that, and that the certificate does take out the holiday function elements of the description developments, the houseboat element remains, and taking a common sense approach to the words used in that and looking at the permission, the houseboat is not a caravan. And the tribunal found it not to be a caravan, and so did the experts. So we're still, even if I'm wrong on the certificate, that certificate is still informed by what was on the site, what was granted planning permission and what was used. Bearing in mind it's retrospective permission, so it was already there. There's no suggestion of any change other than what was granted planning permission was at some point used for a period of 10 years as a residence. And the certificate, however it's interpreted, still has to apply to those houseboats. Or that houseboat, sorry. And that houseboat is clearly not a caravan. It can't be lived in. The caravan can't be lived in. The float can't be lived in. The two parts together what represent the residential accommodation together as one unit. Unless I can assist you any further, I'm going to draw my submissions to a close there.
Questions? Thank you very much. Yes, Mr. Cottle.
Good afternoon. The point that I wish to make in relation to the Mobile Homes Act is to construe the statutory provisions in the context in which they were enacted. And that context has to be understood in the regulatory framework that was referred to in the John Romans Holiday Park case and set out in both the decisions below by the Deputy President, Mr. Martin Roger, in the Roman Holiday Park case. And that understanding of the regulatory framework is really key in my submission when one begins and embarks on the process of looking at Section 1 of the Mobile Homes Act and asking, first of all, is there an agreement which concerns a caravan? And so drinking from the pure waters of the statute, you're looking for an agreement between the parties, the subject matter of which is a caravan. And touching on my learned friend's substantive point that the planning permission was only for X houseboats, I submit that that does trespass on ground one, and I would like to take you very quickly through the purposes, really, of the legislation in this context. One of the first things I'd like to draw your attention to is the Dean case at tab 52, I believe. It's at tab 29.
We don't have tabs.
Right.
Page numbers, please.
502.
502.
I can give you that. It's page
It's
number
502.
502. And turning, if you would, to electronic binding 526. You'll see there highlighted paragraphs 79 to 84. And the mischief that's referred to in the middle of paragraph 79, the mischief which can be identified from these materials is the absence of long-term security of tenure for residents in contrast to the position for private tenants in housing. And then there's identified in paragraph 80, but in my judgment there's a further mischief, in particular discernible from the words of the 1983 Act in reliance on the definition of protected site, which in turn requires reference back to the 1960 Act, which prevents local authorities granting a site licence unless planning permission is in place. This goes back to the origins of the 1960 Act and the 1959 report, which noted, amongst other things, that many caravans were badly located and unpleasant intrusion into the landscape, including in the Greenbelt, a clear reference to planning considerations. And at paragraph 83, there's the reference to the government's explanation of the policy behind the Act, as the object of mobile homes legislation was to remedy a different problem, namely the inequality of bargaining power between the mobile homeowner and the site owner, in which there was a deficiency of supply over demand, which the private sites run as businesses were in a position to exploit. And the paragraph 84, while parliamentary material and other debates tend to focus on the improvement in security, which is especially to be for all residential occupiers, and which is clearly a legitimate aim, there's no indication of any intent to resolve from the previous position that the protection was only to be extended to occupiers on those sites who benefit from planning permission. And that, of course, is what the Balthazar case identified as well, talking about the absurdity, my lady, of a situation where there was a planning control enforcement notice in respect of a caravan on land for which there was no planning permission, and somebody having security of tenure, not being able to remove that person even though they were in breach of planning control. And then I would like to draw your attention, please, and there's an extra page that I've got available, which is the preamble to the Caravan Sites Act 1968. And I've put this one to my learned friend. I just wanted to draw it to your attention.
Thank you. Where do you suggest we put this?
This could go in the tab two, page, just in front of page 15.
Yes.
So we could call it 15A.
Indeed.
Yeah.
So where does the definition of protected site spring from? It springs from an act to restrict the eviction from caravan sites of occupiers of caravans and make other provision for the benefit of such occupiers. And looking through the Act, Section 2 is minimum notice. Section 3 is that it's an offence to evict somebody without due process, i.e. Going through the court procedures. And subsection 1A of Section 3 is to do with harassment. And Section 4 gives the ability of the court to suspend for 12 months. And Section 5, subsection 4, says that if under Section 12, the power of a site occupier to take possession and termination of a tenancy in case of contravention of a licence term, then even in those circumstances, it shall have effect subject to the due process and protection from eviction procedures. And this was on the
which
heels.
provision is that?
Pardon?
Which provision is
Section
that?
5.4, page 26. And this is a 1968 Act legislation which followed up on the introduction of the Protection from Eviction Act 1964 in relation to residential tenancies. So my first submission is that when you're looking at the niceties, my learned friend's points, what you want to be concerned about is that it would be a dislocation of the interdependent regulatory framework for somebody to have security when they're in breach of planning control. But Parliament's intention was that where there wasn't a restriction of holiday use, or where there were times of the year when the caravan had to be removed from the land, such that the residential contract could continue all the year round, in those circumstances, there should be security of tenure under the Mobile Homes Act and protection from eviction under the Caravan Sites Act, provided there was no breach of planning control by putting the land to residential use.
Provided that the site is a protected site and
That's
you're
right.
living in a caravan.
That's right. So
I mean, I don't think you need to persuade us that there are entirely laudable aims behind the legislation. But at the end of the day, the issue is whether or not there was planning permission for this particular houseboat stroke land to be used as a caravan.
indeed. My lady is absolutely right. Under Section 1 of the Mobile Homes Act, and the way that the tribunals below have approached the subject is whether there's an agreement in respect of a caravan.
Yes.
And looking at the Charlton case, Charlton and Howard, at tab 13, page 195, and particularly at paragraph 9 on page 198, what Lord Carnwath then was saying, Lord Justice Carnwath was then saying, it's immediately apparent that something may be a caravan for these purposes, even though it bears no relation to what might be regarded as a caravan in ordinary language. In particular, it does not need to have wheels. It's enough that it be transported on a trailer. And the definition was further expanded in the 1968 Act. This, it seems, was intended to remove doubts about the application of the definition to larger types of caravan. And indeed, it was said by Lord Denning in a case.
Sorry,
following the
Mr. Cook, I'm
introduction-
so sorry. Just before we go on, what was this case about? Because
Charlton and Howard, it was a porch that had been put on a caravan, an alteration, an adaptation. And the point being taken by the site owners was that it no longer qualified under the Mobile Homes Act. And the case turned on the agreement, which was that it wasn't a breach of the agreement to put on the porch. And so therefore there was no breach of the Mobile Homes Act. But the owner's argument was that it no longer was a caravan and the Act didn't apply. So there's actually two strands to that case. But it makes the point about removability of the caravan. And removability was the linchpin of the case of Webb and Frank Beavis, which is at page 98 in your bundle. And this was a structure where it was a shed erected on land 135 feet long and 50 foot wide. It was built of corrugated iron and was laid upon a concrete floor. And just for the court's benefit, it's paragraph H, page 102 of the electronic bundle, page 251. The condition of legal quality of removability namely that the subject matter should not, by the process of removal, lose its essential character or value, was plainly satisfied by the judge's own findings to which I have referred, and I see nothing in the evidence to raise a doubt as to the propriety of that finding.
I'm so sorry, Mr. Scott, this is my fault. Which page are we on?
I was on the electronic bundle page 102, letter H of P251 of the report.
Sorry. Several steps behind the beat. As usual. Page 102. Thank you.
And then if I could take you, please, to the case of Gray and the Secretary of State, which is at page 236 in your bundle. And this was to do with a caravan where there's additional appendages attached. And if I could take you to 243, particularly paragraph 25. And 26 and 27. There the caravan could be pulled up if the bricks and the pillars were broken. It referred to the proof where he listed reasons why the caravan could not be moved, but that did not include the holding effects of the pillar. The inspector also referred to the fact that in his evidence that some pillars were built around the chassis might well be strapped to it. And the inspector went on. However, this indicates that the pillars are not integral to the structure of the caravan. It seems as a matter of fact and degree the caravan could be detached and removed. It's not being shown that the pillars render the caravan a permanent building or attached to the land.
I think we were told that in this case there's no doubt that the caravan is a caravan if you're just looking at it as a caravan.
Well, I would like you to fasten onto that because ground one was dismissed, and what we're talking about in this case is a houseboat comprising a caravan on a float.
Yes.
And one of the questions that the first tier tribunal asked my learned friend was that if the army had a football pitch size of pontoons all strapped together and you were able to drive on with your caravan, would that mean after you've got 50 or 60 caravans there, it wasn't a caravan site because they're all resting on a float? And if you could drive off with your caravans, does that mean it's not a caravan site because once they're on the float, they're dependent on the float? And the argument just doesn't stand up in my respectful submission. It's quite obvious that there's a caravan on a float, and you could call the houseboat with its inverted commas. And the only reason I refer to the officer's report is because it does put inverted commas around the phrase houseboat, is that in this case, you could say the planning permission is for caravans on floats called houseboats. Or you could say the planning permission is for houseboats comprising caravans on floats. But whichever way you put it, in law, the subject matter of it concerns a caravan, which can be towed, and it's still got the wheels on, and there are ramps. And my client, as accepted below, could tow the float and take the caravan on holiday to the Yorkshire Dales.
So
And
we could
that
tow,
makes
tow
the-
the float or tow
Tow
the
the
caravan off the
take the
float.
caravan off the float
Yeah.
and tow it.
Yeah, she wouldn't take the float.
Makes the point that she's got an agreement to station a caravan on the appellant's land.
If you don't take quite such an extreme example as your army one, you had a float which had two of these things on it. Your same point applies, really, don't you? You're in the sense that you're saying it's wrong to view it as a houseboat, a single item comprising the float and the caravan. Because, for example, if you had a float with two of these things on it, you might be more likely to say there's two caravans there sitting on a float.
Well, I'm happy with the concept of a single caravan constituting a single caravan site.
Well, I'm just trying to understand how you're pushing the...
Well, I submit that that was an obvious example of a caravan site. Of course, it's a caravan site. And we know that land is land covered by water, and it's on the appellant's land. I was trying to bring it to your attention that when you've got a statutory definition of caravan, Section 29 of 1960 Act. When you've got protection from eviction measures introduced in 1968, what is the purpose of those protection measures? It's to confer an element of security where people are able to live with agreement without being in breach of planning control residentially.
You say
caravan.
it would
Doesn't have to
be
be permanent.
it would be absurd, you say, or it would be certainly out with Parliament's intention if it made a difference whether the 15 or 16 people, let's say, on the site happen to have their caravans parked on standard caravan concrete posts or concrete blocks on the land, and whether they're actually stationed on pontoons on water. It's still a caravan site.
Well, that's right. If we could look at the patent application very briefly, which you'll find in the bundle. Behind the planning permission, at page 387. They were particularly struck by the fact that whatever it's on, it's still a caravan, as the diagram there shows. It happens to be, the diagram is showing a float, but it could equally well be a field. And whilst we're at this juncture, my client's caravan is at tab 32, page 352, I believe, on the bottom. But my lady already had the point, because you already looked at page 389, the tab, the patent application. You'd already put it to my lady's friend, instantly converting the caravan from being a house on land to being a house on water.
Yeah.
But just above that, if I could draw to your attention the second half of page 389, the invention enables a conventional and unmodified caravan, especially one of a mobile home variety, to be used as a houseboat, and its value depends on the lack of significant planning restrictions in relating to houseboats. And my submission to you is going to be that if in law there is a caravan, then how people describe it is secondary to the substance.
And when you say how people describe it, you mean specifically in planning documents?
I mean that the houseboat, the subject of these permissions, is a statutory caravan on a float. That's the reality. And my learned friend has lost on the, you can't take the caravan off. You've got to see it as one structure. You can't.
That's the ground one.
That ship has sailed, as you put it.
Or that houseboat.
Pardon?
Or that houseboat.
Indeed.
Sorry, that was a silly. I'm so sorry, Mr. Cotter. Which was
It's not a vessel, in fact, because that's another point of the. It's not a vessel.
Not wheels. Yes.
And the Environment Agency at Gibb was a case in the Divisional Court. It concerned this very marina, where they was talking about square platforms with residential accommodation on top. That's not these caravans. It was the other side of the park, of the marina.
Could you just remind me? I'm so sorry, Mr. Cottle. Which bit of the patent application refers to the planning restrictions?
389.
389. Whereabouts?
It's in the
in the
bottom
middle, I think.
paragraph. Lack of significant planning restrictions.
Oh yes, I see. Yeah, thank you.
So they know what they're doing.
Yeah.
But the point of the legislation, the Caravan Sites Act, the point of the Mobile Homes Act legislation is you've got, wherever it is, 250,300,000 people living in mobile homes up and down the land, is whether or not they should have security of tenure, and whether or not the owners of the property should be able to determine their contractual interest without there being any protections. And
Well, of
what you're
course.
talking about is whether the substance of the arrangement between the parties meets with the statutory criteria. And you start from section 1 of the Mobile Homes Act. And I also, if you'll bear with me, like to take you just to the Uber case, which we find at page 384. If you just bear with me for 5 minutes on this, page 384, tab 25.
Is that the case about employment status?
That's right. And first of all, if I could pick up the judgment at paragraph 58.
Oh, I'm still trying to find it.
The Autocleanse case. Where there's a distinction that's being made in paragraph 60 between employment contracts and other contracts in terms of the terms of the agreement. And then at page 403 of your electronic bundle, paragraph 69, critical to understanding the Autocleanse case as I see it is that the rights asserted by the claimants were not contractual rights but were created by legislation. Thus the task for the tribunals of the courts were not, unless the legislation required it, to identify whether under the terms of the contracts Autocleanse had agreed their claimants could be paid at least the national minimum wage or receive annual leave. It was to determine whether the claimants fell within the definition. And the modern approach to statutory provisions at the top of page 404. And then there's a quote from Lord Reed in the Collector of Stamp Revenue case that the ultimate question is whether the relevant statutory provisions construed purposefully were intended to apply to the transaction viewed realistically.
I'm going to make a slightly nerdy point about bundles. I'm sure this case is reported in the law report. Really ought
Of
to be.
course, I've got it in the ICR's 2021 Industrial Case Report 657.
It may well be in the appeal
I think so.
cases as well.
I had my cases prepared before I got the bundle, so I've got them all.
No, I'm just making the nerdy point that the law report ought to be in the bundle, not the transcript.
Of course. Quite accept that. Looking at paragraph 87, in determining whether a worker is an individual is a worker, there's no substitute for applying the words of the statute to the facts of the individual case. And no substitute for applying the words of the statute to the facts of the individual case. And the words of the statute here, understood in its legal and factual context, is quite clear that security is intended to be conferred on those whose residential use is not limited by a planning condition that limits it to holiday use or times of the year when they can't be there. The purpose of the provisions are to apply if there's no breach of planning control by living there. Otherwise, it's an absurdity. And then I would like to take you to the case of Holmes and Cooper, tab 9, page 135. Electronic bundle 1, and at page 138 in the report.
I do understand your point about the intention of Parliament being to confer similar protections on somebody who lives in a mobile home, somebody who rents property in the private sector. But of course, that rather begs the question, it would be said against you, well, these mobile homes or houseboats, however you care to, were never intended for permanent residential use. The whole purpose of this development from the word go was to create structures that fell outside of the Mobile Homes Act 1983.
Well, my lady, what I'd say to that is that obviously it benefits the marine park owners to have a constant stream of income during closed seasons.
Yeah.
And when they have people who have second homes who retire and then move to the marina, having sold their former homes, and they continue with they must be turning a blind eye to what's going on. And what's happened is that you've got residential use of these caravans that has sort of grown. And apparently, you can see it from the officer's report, how many cluids have been granted on other sites in the marina. And the advertising material that you were shown by my lone friend this morning talks about permanent berths there. It has changed over the years. And you might say that people took advantage because the planning authority weren't zealous in their enforcement because it went on for so long.
Sorry, I haven't picked up that reference in the officer's report. How many other certificates have been granted?
Well, there is 11, but obviously that was then, and this is now.
Sure. No, just as a matter of...
And that was 11.
And that was already by 2014?
That's right.
Okay, thank you.
And as I say, the advertising material for the marina included residential berths.
Well, I actually looked at the what I thought was the advertisement for this particular property.
It's residential.
Which it says it's residential use.
And they had agents.
Yeah.
Hartford Marina had the agents who were introducing the purchases.
Yeah.
And everybody knows that the cluid changed the nature of the use. It was no longer in breach of planning control. That's why they were obtained.
And in any event, this position would only arise if you had someone who'd been using it for residential purposes for 10 years.
Exactly. And the point of the Act is that once the prohibition on holiday use has fallen away, you're not in breach of planning control. And there's no purpose achieved in therefore denying security of tenure. It's not achieving any social policy purpose.
Well, that rather begs the question, because the argument that's being put against you is that you are still in breach of planning control.
Well, that was said by Judge Cook to be contradictory and pointless, and to have a functional limitation that prevents all the time residential use, and to say that a certificate for change of use that allows full-time residential use doesn't affect the description of the planning permission is contradictory and pointless. Of course, the officer should have referred to the limitation as well as the condition throughout that report. And that's the mistake, that's the deficiency. Because I'm your man was applied too strictly. And what Lord Justice Sullivan in the Winchester case in 2014, after these certificates were granted, I hasten to add, did was to clarify.
Yes.
And what we know from the Lambeth case is that there can be wordings in certificates and provisions and permissions which don't actually capture the full legal context. And my lady talked about a liberal construction. I asked the court to apply it in its factual context.
Well, I was only referring to the well-known principle that you don't construe a planning permission like a statute.
Well, the learning is that there should be no difference in approach to public documents as there are to contractual provisions, but to take it in its particular factual context with the knowledge of the people who
to whom it's addressed.
That were involved. and includes the documentation that's referred to on the face. But I say in relation to that certificate, it's by virtue of the facts on which the certificate was based. By virtue of the facts on which the certificate was based, that certificate touches on the limitation, the functional limitation, the description, as well as the condition. And to say that it does one and not the other is, as the judge described it, contradictory and pointless. So really, the appeal in this case, in my submission, comes back to the first point, which is the one that...
Sorry to interrupt, Mr. Colvin, but so if the result of construing the certificate in the way that the appellant would have it construed is that it's contradictory and pointless, that may be a reason for construing it in a different way.
Yes, the opening words of the certificate are entirely consistent with 191A.
Yeah.
And what it's permitting cannot be said to not touch the description. It is a change of use. Because the example in the Winchester case was between cattle, trucks, and general haulage. The example in the other case was between travellers and non-travellers. And here we have an example in between the description of planning permission restricted to holiday use and non-holiday use. And it's as much a change of use, even, as you put it to my learned friend, even if the condition wasn't there. The description of planning permission restricts the use. And my lady had said, well, if you carry on the same use, it's not necessarily a material change unless the intensification makes it a change of use.
Yes.
But when there's a different type of use, it's generally acknowledged that because of the infrastructure the local authority might have to provide with residential use in terms of schools, there is a difference in character between holiday use and full-time residential use. And this is for full-time residential use. So therefore the purposes of the restriction in section 1 of the Mobile Homes Act, which was to disapply the security provisions where you weren't allowed to live, therefore is fallen away. And so I would...
Section 1 of the...
Mobile Homes Act. So I would say that the description and the planning permission is no longer operative.
What you mean in the original grant?
That's right, yes. The holiday use. It's overtaken by the certificate. Because the certificate is
But just
acknowledging.
looking at it extremely simplistically, which I try to do, looking at the face of the certificate itself, it says it certifies that the use for residential purposes is lawful. It gives reasons why it's lawful. And the reasons why it's lawful is because it's been used for that purpose in breach of planning permission for the last 10 years, because it's been in breach of condition. But the fact that it's a breach of a condition is the reason why it's lawful. That's what the statute says you've got to say. You've got to say, why is it lawful? It's lawful because you've been doing it for 10 years. In breach of a condition, but I can't at the moment understand how that doesn't mean that you are lawfully residing there, that you've got planning permission to reside there. The distinction between, in this context, between a lack of enforceability and permission to do it, seems to me to be a distinction without a difference.
Well, I come back to 191, 2 and 3, which I asked my learned friend to read out, which is that when you've got a limitation, we can talk about the description of the planning permission being a limitation. That's
Yes.
referred to under section 171A, describes breach of planning control as breach of a limitation.
Yes.
And the officer didn't refer to breach of condition and breach of limitation.
Yeah.
But if you think about it, if the limitation as well as the condition has fallen away, then your relevant planning permission for site licensing purposes is that certificate. And it's one and the same.
Yeah.
And these submissions are to be found at page 277, tab 24 in volume 1. And my lady, I did want to take you to this document for a number of reasons. Before we get to the point that I was just about
Is
to...
this your post-hearing note?
Yes, and just about the procedural observation, it just occurred to me that if you're dealing with second appeals, it's customary for this court to sort of drop the intermediate decision. We'll look at the first one, but in fact here, the second one has revisited all of the first findings. So really, it's not possible to adopt that approach. And we are looking at Judge Elisabeth Cook's Upper Tribunal decision on both matters. And that was because it wasn't argued in the first tier tribunal in the way it's been argued now, because then the argument was you don't have a protected site because it's not a planning permission for a caravan site. It wasn't arguing in relation to the certificate so much. It only came up at the very end. And what was said on page 278 and 279, the submissions that were being made is the planning permission for the purpose of deciding if a caravan site is a protected site is the operative one for site licensing purposes. And it must be the case, given how close the Caravan Sites Controller Development Act 1960 is drafted in the context of planning. And that's that close relationship between the two acts.
Sorry, between the which acts?
Between the site licensing provisions and town and country planning. Town and country planning came first, site licensing came second. And there's a close relationship between the two. And when you're talking about the relevant planning permission, it must be the same one for site licensing purposes. And that again adds fuel to the judge's comment that contradictory and pointless. If you've got an ability to have a permission for site licensing purposes, how on earth can you envisage it being different in the circumstances of there being a certificate saying it's lawful to use the premises all the year round? And the submission, page 279, is the certificate was for change of use. That was the submission that I was making below. So I just wanted to come back to...
Before you actually get on to that, there's clear water between you and your learned friend as to whether it was a 11A permission for change of use or not. But what do you say if you were wrong? Let's just suppose that on the true construction of this certificate, it's a certificate to under C rather than A. Would that make a difference to your position or not?
If I was pushed, and my respondent's notice obviously argues the other way, but if I was pushed, I would say that if the functional limitation is still left there, it's no longer operative because of the certificate. Even if the certificate was deficient and not understood in terms of 1A, that limitation, because of 1912, because of 1913, because of 171A, the definition of breach of planning control is there, breach of limitation. And the definition of lawful in 191 is when something is beyond the period for the time of enforcement. And my learned friend was asked by Lady Justice Laing whether there was still a breach of planning control by non-compliance with the terms of the description of planning permission that restricted the holiday use. And my learned friend's answer was quite wrong, because of course the facts on which the certificate is based show that that breach has been going on since 2002. 171B tells us that it's immune from enforcement after 10 years. And 1912, 1913 tells us that it's lawful if it can no longer be enforced against. And so the answer to my lady's question was no, there's no continuing breach of planning control. And it was a question my lady Justice Falk asked quite early on in the proceedings. There is no continuing breach of planning control. And that comes back to the point that I began on, which is that the facts on which the certificate were based is what you're looking at.
Yes.
And in effect, it was a 191A, 191C, it was both. It was breach of condition because they've got belt and braces. You've got a description of planning permission and you've got a condition. But because in the pre-Winchester days, they were understanding from I'm Your Man that what's said in the description of planning, it doesn't matter.
Yes.
The officer didn't refer to it. But every time he referred to condition, he should have referred to the limitation in the description of planning
So I
permission.
think I now understand. You say only in the light of Winchester
I'm your
should
man
it
being,
have become apparent that you should have referred to the limitation in the body of the
That-
description as well as the condition.
because there's still a change of use going on, away from holiday use to. So I submit that the construction of the document in its legal and factual context is that it was overtaking the functional limitation in the description of planning permission. That's the truth.
Because what would be the point of saying the breach of condition was all right if you weren't also overcoming the limitation in the description?
Judge Cook said, I can't see how it doesn't affect
Back
it.
to your contradictory and pointless argument, isn't it?
But I think the point you make about the lawfulness that arises simply because it's unenforceable is quite a powerful one.
I suppose there is
There's no
possibly a technical difference, is there, between something being unenforceable and something being sort of positively lawful.
Well, that was the point from the Broxbourne case in the 70s, and what Robert Calmouth did in the Calmouth Report on Planning Control in the 70s. He said we should have greater clarity on that. The 1991 Act added in subsection 6 that wasn't there before to make that point clear, that it's lawful, even because before it was a bit messy, just being immune from enforcement but not lawful.
Oh, 191 said it.
Yes.
Yes.
Well, it's conclusively presumed to be lawful. So it's a
Well, 1912 and
Yes.
1193 is saying it in terms of
Yeah.
And that's the point of my learned friend, is that really you don't need to go behind the certificate. But the reasons don't define the grant. So I got as far as the Holmes and Cooper case, and it was to page 138 in the electronic bundle. It's reporting the weekly law report from 1985, volume 1, page 1060. It's at paragraph G. If I could invite your attention, please, to page 138.
This is Holmes and Cooper, yes?
That's right. And the object of the Act is to control sites where people are living. At the same time, bearing in mind the exceptions that are listed in the schedule, that's the schedule to the Caravan Sites Act Control Act, where no licence is required. One can see that there will be those exceptional cases which are dealing with ad hoc situations, very largely, where the same measure of control would not be justified for a particular variety of reasons, and which can be seen and examined each of the particulars. But the object or purpose of the Act being as I stated, it seems to me that it be inconsistent with that purpose to deprive a person of the protection of the Act who does not himself or herself come within the exceptions. And
Yes.
the last case on this point, or the penultimate case on this point that I wanted to draw your attention to is the Elmdene Estates and White in 1960 appeal cases, House of Lords, page 104 in the electric bundle. And page 538, 114 of the report. And I don't know whether my lady had read this before I got to it, but just short before the adjournment, my lady had mentioned substance and reality. It's in the middle of page 538, 114. Do you have it?
Yes.
And my lords, it's been said before, it must be said again, that in consideration of questions arising under the Rent Acts, the court must look at the substance and reality of a transaction. And in my submissions below, I was referring to Aslan and Murphy, where Lord Donaldson was saying there's very little that can be relied on in terms of the labels that people might put on an agreement, and that stemmed from Street in Mountford, where Lord Templeman said that the manufacturer of a 5-pronged instrument for digging may insist that they've made a spade.
Yes, but it's a fork.
And that, in my submission, is supported by the Melliwish case, where you've got a transaction, the local authority agreeing with a company that plant and equipment that's incorporated into their buildings is owned by the company. And the inspector of taxes complaining that it's part of the realty. Doesn't matter what your agreement is. Doesn't matter that you've got an estoppel. And what we're asking
Your
to
point,
do,
your point is you can call it what you like, but it's still a caravan on a pontoon.
and so my Lady Justice Laing was saying, well, look, it's talking about houseboats. And my submission is that it's houseboats in inverted commas. It's Hartford houseboats. It's a peculiar, unique, you could say, clever, you could say, idea. But that's what a Hartford houseboat is. It's a statutory caravan with its wheels on a float, that hasn't lost its identity. And a lot of my learned friends' arguments on the functional limitation of houseboats is destroyed by ground one having been dismissed. He doesn't recognise in full force the effect that the houseboat that he's talking about is a caravan on a float. And the last point that I wanted to add was that in the description of planning permission, if we could just go to it, please. The description of planning permission. Which is at page 379.
Is that the first volume or the second?
It's in the second volume.
It's in the second, isn't it? Yes.
And I just wanted to draw out a point about the wording of it. It does say retention of use,
Yes.
and it also refers to ancillary development, whether that's associated development, incidental development. But I just wanted to draw our attention to page 432. And this is an RSJ, or one of several RSJs, driven into the ground for the main pontoon. And the planning permission included the pontoon. And the pontoon is clearly a building, a structure for the purposes of operational development. Something that's built. Section 55, building operations, something that an engineer would normally be involved in. But it's just odd that the description of planning permission at 379 isn't referring to the main pontoon, which is a substantial item. So one is left guessing that it's associated development that's being referred to by the ancillary development phrase there.
Well, let's just have a look.
Ordinarily incidental.
Well, unless it encompassed within the word houseboat, I suppose.
It's something to put the houseboat against.
But you're talking about the main pontoon, not the individual
That's
float
right.
the houseboat is on.
Oh, right. Right, sorry.
Because that floats,
Yeah.
whereas the pontoon
Stuff,
has got
yeah.
legs.
Rooted, yes.
Right.
I just make the point that there's something incomplete about this permission because it
Although
obviously,
we don't know whether prior permission was granted for the pontoon.
well, the answer to all of this is a Malin friend pointed out that it refers to the drawings and documents which form part of the application,
yes.
and of course they've granted permission for what they had in front of them,
Mm.
and we all agree that what they had in front of them is as described in the patent application because it was there already.
Mm.
It was there already in place before they granted permission.
Well, the pontoons with the house.
That's
with
right.
the houseboat.
With the caravans was already there. And just on the point of being already there, if I could take you to the University of Leicester case, page 250 in your bundle. And there, the interpretation of a planning permission is set out at paragraph 42 on page 260 of the report. And just a word of qualification in relation to what my learned friend talked about the Ashford case. At paragraph 43 on page 261, Lord Justice Keane doesn't recount exactly, but he says that he agrees with Mr. Justice Sullivan's observation that what he was talking about in Ashford was just an outline planning permission. And it's plain on the face of the permission, it's a full permission for construction, erection, or alteration of the building. The public will know that in addition to the plan, there'll be plans, drawings, describe the building works which have been permitted, precisely because the permission is not on its face an outline planning permission. Those plans, drawings, describing the building works are much as part of the description as what have been permitted as the permission notice itself. It's not a question of resolving an ambiguity. You can have a look at those documents. And in this University of Leicester case, there'd been a planning permission for student accommodation, and the application and the 106 agreement had concerned use of the student accommodation during vacations for conferences. And the question is whether the conferences were out with the terms of the permission or within it. And it was decided that the university did have planning permission for the conferences. And what's said on page 263, paragraph 48, is a reference to Lord Justice, Mr. Justice Linwood, as he then was, in a case called Wood and Secretary of State. And he refers to Campbell. Sullivan, faced with the need to construe a planning permission whose full meaning was not apparent from the decision notice itself, was prepared to consider the application for permission of the site plan and relevant planning officer's report. Having done that, he said that he did not see why the consideration of extrinsic evidence should be confined to documentary evidence, and that in the circumstances of the case before him, he didn't see why it should not be possible to have regard to what had taken place on the ground. And my submission below, and my submission at the Upper Tribunal, was that when the planning permission was granted, they could see the caravans. And they could see that they were on floats. And it's that use of the inverted commas, what we're talking about here. And there's a case called Sussex Investments and the Secretary of State at page 142. And there it was decided that the particular structure there, square platform with residential accommodation on top, wasn't a houseboat for the terms of the permission there. It's confined to its facts. It was just a question of fact and degree. But I just wanted to take you to the commentary, if I may, at page 151, where the author says, paragraph B on page 152,
Give us a chance to get that, please. 152. Yeah.
the problem with this approach is that the term houseboat is very vague and imprecise. It could include any craft which look like boats but are used for residential use. It could be stretched to include what are simply floating houses. And Lord Justice Walker had talked about the typical houseboat, didn't state what the typical houseboat, but it did not state what was the typical houseboat. And then it goes on to add questions of law. The present case is a good example of a case where, despite the unusual nature of the craft, it could be legally held to be both to be and not to be a houseboat. Perhaps planners should therefore steer clear of using this term, houseboat. And the point is that we've got an agreement.
So what was actually at issue in the Sussex
Whether or not
case?
it fell within the particular, whether the particular structure.
No, but I mean, what was the nature of the object?
It was a square platform with residential accommodation on top.
Right.
called a houseboat. And if I could take you to the First Tier Tribunal's corrected decision, page 161, tab 17. It's at 169. The paragraph 20, do you have it on page 173? Set out the facts of the surveyors. Do you have it?
Page 173.
Yes, paragraph
Is it
20.
Mellish and BMI. number
No,
3.
we're looking at the call.
Oh, the Upper
Oh, sorry.
Tribunal.
Oh, I do apologise.
You're jumping around between bundles quite
Yes.
a bit. Poor bundle.
And paragraph 20 has the findings of the joint experts. And one is the Willoughby caravan is completely intact with both chassis and wheels. 5, the Willoughby caravan simply sits on the frame, the pontoon is not secured or otherwise attached. The caravan is connected to mains water electricity. Point 13, the caravan could easily be lifted off the pontoon and transported by road or other means. And point 16, over the page, the houseboat is not a vessel. And then there's the reference to the Environment Agency in Gibbs case, at paragraph 28 on page 175. And what's said by Mr. Justice Tier then, Admiralty judgment, was it's true that the houseboats were constructed and used to support the weight of living quarters and of those persons who live in them, but it doesn't amount to houseboats being constructed or used to carry persons or goods on or by water. And the point is that my client, as you've seen from the documents, has an agreement in respect of a vessel. And the point really about the rent acts is to look at the substance of the arrangement. And Street and Mountford is talking about.
Sorry, are you saying that the mooring agreement
Doesn't-
uses the concept of vessel?
That's right. Yes, she
Right.
signs up. She signs
So
up.
you're
To
saying
It's not a
Street and Mountford, you've got to
look at the substance
look
and
at the
reality.
substance. It's not actually a vessel.
That's right. Everybody agrees it's not a vessel. But that's what her agreement with Tingdene that they're relying on to serve notice to quit says it is.
Okay, I'm not
We don't-
completely sure how that fits into the argument.
Well,
we're
what I'm
having.
saying is that there's a vagueness about the term houseboat, and it really does yield to the particular facts of the case of what is in issue. And there's no ground one permission in respect to the challenge to what the subject matter of the agreement is, which is a caravan on a float. And that, in my submission, severely undermines ground 2, because it does mean that the planning permission, the retrospective planning permission for what was already there, was a removable caravan on a float.
So the subject matter of the agreement has been found to be a caravan on the float. And you're saying effectively the planning decisions must relate to that.
That's right. The way that the Upper Tribunal dealt with it is in the bundle there. Paragraphs 47, 48. My learned friend has already taken you to them. And what is meant by a houseboat? My lady Justice Laing was saying that there were 2 sentences in paragraph 48 which didn't quite follow. which is that the permission is a planning permission for a caravan site. It's not a permission for the stationing of caravans other than in the form of the houseboat. It's a
Sorry,
per-
where are you reading
This
from?
is paragraph 48 of the Upper Tribunal decision at page 93.
Yeah,
The 1998 permission is a planning permission for a caravan site. It's not a permission for the stationing of caravans other than in the form of houseboats. It's a permission for a limited form of caravan site, but it's a caravan site nonetheless. My submission is that the permission for houseboats was a permission for statutory Willoughby caravan, in this case, on a float. That's what the Hartford houseboats comprise, and that's what they knew that they were granting permission for.
so for example, if those structures were removed and replaced by another form of houseboat, that wouldn't necessarily be within the permission?
We'd have to
because
come
it's a-
back to section 29 of the Caravan Sites Act and section 1 of the Mobile Homes Act and ask if that was a caravan. You're contemplating a different scenario of a different
Well,
residential
no,
structure.
I'm actually focusing on the permission because you say the permission was for what was there.
Indeed.
So if, for example, they scrap the whole arrangement of the pontoons and actually moored real vessels there, which people might live on, that wouldn't necessarily be covered by the existing planning. Or on your case, it wouldn't be covered by the existing planning permission, because houseboat in the planning permission actually means a caravan on a float.
It means the Hartford houseboat, the subject of this
Yes.
application
Yeah.
only.
That's what I'm saying.
Only,
So if
yeah.
you replaced it by something else,
That wouldn't be the Hartford houseboat.
it wouldn't, because the what was granted was related to what was there.
The officer's report even goes so far as the open inverted commas Hartford style houseboat,
Yes.
close inverted commas. That's what we're talking about.
Sorry, is that the officer's report for the certificate?
That's right, yes.
Yeah.
Because it is a particular thing. But if you turn the clock back to my earlier submissions as to the close relationship between the planning legislation and site licensing controls, and you see how closely related they are, and then you understand how security of provision came in subject to Parliament's very firm resolution that there shouldn't be this absurdity of anybody getting security that's in breach of planning control. And then ask yourself whether the terms of this planning permission mean that it's a breach of planning control for my client to live there all the year round. And quite clearly, that's not the case. And it's right that long-term residential users should have security of tenure in substance and reality if that's what's going on.
Well, wouldn't that be your submission regardless of whether there was a certificate of lawful use?
I'd have to have the 10 years.
Yes, but let's suppose you've got your 10 years, then you've got subsection 6. Why do you need the certificate of lawful use?
Well, the certificate tells me it's lawful.
Yeah, it tells you it's lawful.
It's immune from planning. If your scenario, my lady, is beyond the 10 years,
Yeah, it's immune from planning control.
I wouldn't like. I mean, whether I was on thinner ice or not, I haven't thought that one through.
I was
But
just,
if you've got a functional limitation that's OTOs,
Hmm.
that's been overtaken because it couldn't possibly be enforced against, and so therefore we know that it's open to a certificate being granted tomorrow.
yes.
Yeah.
That sort of situation.
The 1916 has a conclusive presumption if there is a certificate in
Yes.
force,
Yes.
which may.
And you come back to a site license being required, and a site license is required where there's a caravan on land. And my learned friend argues that that has a knock-on effect. But the local authority, in terms of their enforcement, are not going to be stupid about it. They've missed the point, and now it's a caravan site. things can be organised differently with terms of site
When you
licence,
say they've missed the point, you mean they failed to take planning action?
or regarded as a
enforcement
caravan.
action.
But now we've got a decision. Things can fall into place. It's not unheard of. It's not that there's no need to frighten the horses over this. They're perfectly capable. Tingdene operate a lot of caravan sites as well as marinas. Not unfamiliar territory to them.
Well, it only becomes relevant if wherever they're operating it, there are people in the same position as your client.
Indeed, my lady.
But the 10-year period and the full residence, because as originally the concept as originally envisaged was for holiday homes, and it didn't really matter in those circumstances because the provisions of the Mobile Homes Act would never bite whilst they remained holiday homes.
But from what you're saying, the number of certificates of lawful use suggests that quite a few people are in this position. It's not just your client.
That's correct. But we don't know about their individual structures, whether they've carried out some adaptation, knocked out a wall, or made it of such different character. We'd have to look at each one individually. But the holiday use would still very much subject to site licensing.
Yeah.
But is there a planning permission that restricts my client to holiday use only? No.
No.
Is there a time of the year when she has to leave? No. So therefore, in my respectful submission, the appeal should be dismissed, because Section 1 of the Mobile Homes Act is made out. So there's nothing in my submission to indicate that the tribunals below have misdirected themselves or interpreted what's gone on in any inconsistent way with the principles for interpreting a planning permission. There's no error of law in taking into account what's happened on the ground. And in my submission, there is a need to look at the substance and the reality. And labels are not the end of the matter.
Does that cover the point that's made against you with some force that the permission is for the whole structure and not for bits of it, and therefore the permission is only for the use of the caravan plus the pontoon and not the caravan as independently as a caravan?
It does, because for the purposes of Section 1, there is a caravan that is the subject of the agreement. And the caravan and the float are two detachable parts.
Yes.
So my own friend is really just repeating the point that he's always been saying, which is it's indivisible. It's indivisible.
Right.
It's indivisible. It's indivisible.
So you say that the grant of the planning permission, you look at the grant of the planning permission as a matter of substance and reality, and it's by reference to what was there. However, it's described as a houseboat. It's actually a caravan on a float. And you can't say that your client has not got planning permission to use that caravan for residential purposes. And once she's able to use the caravan for residential purposes, she has the protections of the statute.
That's what the statute
That's
intended.
effectively what was intended.
But I think you're also saying look at it through the lens of Section 1 of the Mobile Homes Act, the starting point for which is the agreement with the occupier, and you said that's why ground 1, the ground that hasn't been permitted to go forward, is unhelpful to the appellant, because your starting point is common ground, as it were, that there's an agreement in respect of a caravan.
And so the relevant planning permission doesn't prevent us from living there.
No.
If it did, then Parliament wouldn't want us to have security.
Yes.
Yes.
So you say the only really sort of relevant bit of what Parliament was intending in relation to bringing in a planning angle is to stop people getting security in circumstances where there is a breach of planning control.
That's the absurdity point that runs through the authorities.
Yes.
For somebody to be breach of planning control, to have an enforcement notice, not being able to do anything about
Yeah,
it.
but that's the function of the planning link, if you like.
That's
That's the aim of the planning.
Because the control of caravans comes first.
Yeah.
The public interest in planning control.
And you say that link is present right from the get-go because it's there in section 1, subsection 2 of the 1968 Act.
Indeed, and we know that a licence can't be issued under section 3 of the 60 Act unless you've got planning permission. So
Yeah.
the whole thing links
So
together.
the two things have been linked from the beginning.
Very much so.
Yeah.
There's what's called a close relationship, interdependent. I prefer to submit it's just dovetailing. And the danger would be to dislocate it somehow. And there's no dislocation of the three regimes by security being conferred on the basis that there is a planning permission. There's a planning permission for what my client lives in. And it's not restricted in a way that would prevent it from being protected. So I don't know whether I can assist you any further.
Thank you very much, Mr. Cottle. Any reply?
Yeah, just in brief, if I may. You will have at page 54 of the bundle the grounds of appeal that were pleaded. It is plain as day that ground 2, first limb of it, relates to the interpretation of the planning permission. That is ground 2 is what has been granted permission for. I say that the Upper Tribunal has erred in law in two respects. A, in finding that there is a planning permission for the stationary caravans on land. So that is fairly and squarely before your ladyships. It's important, I say, in this context, not to overcomplicate the process. The starting point here is there a protected site? It's as simple as that. If there is not a protected site as defined by the relevant statutes, there can be no agreement under the Mobile Home Act, regardless of whatever approach it is application that you take to statutory interpretation. It has to be, the starting point has to be a protected site. Now, my learned friends relied on a number of cases where the courts have considered structures as that involve caravans, and I'm sure in due course you'll consider those. Those generally are cases where there is an argument about whether something is a caravan because things have been bolted onto it or there's been additions to it. They're not relevant in this case, they're not helpful. What we're dealing with here is the interpretation of the planning permission in 1998. What did the planning permission provide for? And my learned friend has quite helpfully set out his position in that, as he said, that the planning permission was for what was there, plainly, and the officer was entitled to take into account what was on the ground, so to speak. There's no ambiguity in the planning permission. It is for a use of land. That is what it says. Use for the houseboats. Use land for houseboats. and it says houseboats, what it means by houseboats, and my learning friend obviously agrees with this, is what was there, what was seen, what was present. It's not limited to the Hartford houseboat at all. In that context, the permission says houseboats. But the permission is also subject to a condition that says that the condition 2.
So do you agree that, is it common ground therefore, that the permission relates to what was there?
Yes,
Right.
Sorry, what page? Remind me.
the permission's at page 379.
Thank you.
You see condition 2. Says the houseboats hereby permitted shall not be extended or altered externally in any way without the written permission of the local planning authority. It's always been the appellant's case that the permission was for what was there, because the permission expressly says retention. You can only retain something that's present.
But it condition 2 in a sense reinforces that it's those houseboats,
Yes, I understand that.
those particular.
Yeah, those particular houseboats as seen. It's not, planning permission is granted, what is seen is a structure that is floating on the water moored to a pontoon. The Maloney firm wants to separate it out into a caravan and a float, and we could also pop in boarding so that the float is usable, railings so the float isn't dangerous. But the fact is, it's the houseboat as in its entirety, in its entire structure. In granting planning permission, I say it's absurd that the planning officer would be in contemplation that the unit could be split into its constituent parts, and that the caravan that forms part of the houseboat could be placed on land separately. That is not a logical or common sense approach.
I don't think the respondent is relying on it.
No, but the Upper Tribunal said the houseboat is not a caravan because it fails the mobility test. There's no challenge to that. There's nothing suggesting that the houseboat, this has been granted planning permission. And as the planning permission states, it's a planning permission for the use of land for houseboats. That has to be interpreted as to provide for a caravan site. There is no planning permission, in my submission, unequivocally, there is no planning permission that allows for the stationing of caravans on land.
So you're not allowed to station a caravan on the pontoon
On the pontoon or the float.
either?
Well, no, you're not allowed to station it on the pontoon because the planning permission's for the houseboat.
Are you allowed to station a caravan on the pontoon? Or on the float, rather?
Well, the caravan is part of the houseboat. So the houseboat is stationed on the land. The caravan is located on the float. And given that planning permission was granted for what was there wouldn't be planning permission to put the caravan on the pontoon. That wouldn't comprise the houseboat, which is the subject of the permission. There's no dispute that the Willoughby caravan can be taken off in the same way that you can take windows out of a house. But the whole of the structure that was granted planning permission is the houseboat. The houseboat is not a caravan, and there is no planning permission that allows for the caravan alone to be placed on land. And there has to be for there to be a protected site. And if there is no planning permission to place the caravan on land, and the caravan in this case is just the Willoughby, then there can be no agreement under the mobile home there.
You say it's not good enough that the caravan is part of a structure that for which there is permission to be placed on land. You say it doesn't matter that Parliament intends what is quite clear, which is that there should be security of tenure for people who are not in breach of planning permission and living in a caravan when they're not in breach of planning control.
The security of tenure flows from the grant of a planning permission for a protected caravan site. That's what provides for the security of tenure. So the starting point has to be identification of a planning permission for a protected site that provides that security. That has to be fundamentally the approach to the determination of whether.
Sorry, just for my benefit, when you say the planning permission has to be for a caravan site, can you just take me very briefly again to the statutory provision that actually says that? Because I'm not sure it's put in quite those terms, but I'm probably missing something.
Bear with me a moment. So the Caravan Sites Act, section 1968, section 1, page 15.
Yes, I've got that. But it doesn't quite put it in the way that you just said.
Well, it says that for the purposes that's part of the Act, a protected site is land, any land in respect of which a site licence is required. And it says not being land in respect of which the relevant planning permission or site licence. So there has to be a relevant planning permission in place.
Yes, I understand that, but as I repeat my point, I don't think it's quite in the terms that you.
The point is that on this, in relation to the land occupied by the respondent, the relevant planning permission is the original planning permission as varied by the condition of lawful use. And that, unless you're right that the original plan always inhibited the use to holiday use without the condition being present, on the face of it, the grant of the certificate means that you take that inhibition away, and so it's no longer within the proviso.
But the certificate, something has to inform the interpretation of the certificate. Yeah, it has to relate to something. And what it relates to are the houseboats or the houseboat. The accommodation is described in the certificate.
Well,
which is
surely it's land in respect of which the relevant planning permission.
Yes.
It's just, you can use that. I mean, subject to your point about 191. It's just land. Which you
but
can
you're
use
not.
for residential.
Yes, but you're using the land for the stationing of a caravan. That's the key element.
No, but I'm trying to find
Yeah.
that in my point is I'm struggling to see how that is expressed in the statute. I'm also looking back at the 1960 Act. I don't know if that is relevant. The source of the Balthazar point is the 1960 Act, isn't it?
So let me. So you have section 1(2) of the Caravan Sites Act 1968.
Yeah.
It talks about protected site being any land in which a site licence is required.
Yes.
And section 1 of the 1960 Act, Caravan Sites Control Development Act, So subject to provisions as part of the Act, no occupier of land shall after the commencement of the Act cause or permit any part of the land to be used as a caravan site unless he is the holder of a site licence.
Yes.
Okay, and then if you turn to page 4,
Yeah.
it's the issue of site licences.
Yes. Section 3.3.
Section 3.3, local authority may in an application under the section issue a site licence in respect of the land if and only if the applicant is, at the time when the site licence is issued, entitled to the benefit of a permission for the use of the land as a site granted under Part 3 of the Act of 1947, but we take that then to as the 1947 has been superseded by subsequent Town and Country Planning Acts. So there has to be a planning permission in place. There can be no agreement in the Mobile Homes Act that provides for the occupation of a caravan that isn't lawful in the first place.
Okay, but is the answer to my question in section 3.3?
Yes. Because the whole, it's a bit tortuous, I accept that, and you've got to link back through the 3 acts, if you like, starting with the Mobile Home Act, section 1, then to the Caravan Sites Act 1968, and then back to what is it that provides for a licence to be granted. In order to have a licence, you have to have a planning permission, and the planning permission has to relate to caravans.
Well, the planning permission has to relate to the use of the land as a caravan site.
Yeah, and
that's defined in section
Yeah.
1, subsection 4 of the 1960 Act. Land on which a caravan is stationed for the purposes of human habitation.
yes. So it could be more straightforward. It could be boiled down in a bit more of a convenient way. But if
This
you,
is land on which a caravan is situated for the purpose of human habitation, and that's the problem.
well, in my submission, it's not, Your Ladyship. It's land on which a houseboat is located. It's accepted that in the construction of the houseboat is a caravan. Within that, the planning permission has been granted for the houseboat. To suggest
We're going round in circles. It's the same point, isn't it, really?
it is the same point, but what do we do with the float? So if it's suggested that the caravan is stationed on the land, what's the float? What provides for the float? What planning permission? What is it? And the reason that there's no answer to that question is because the planning
permission
permission
for both elements.
together as a houseboat.
It doesn't matter whether they're together or separate. They are in one site, and there wouldn't be planning permission for them to be on a different part of the land. They're together. But it doesn't stop a caravan from being a caravan.
But the caravan, no, it doesn't. I accept that, and that's never been part of the appellant's case. But the caravan is not on the land. The houseboat is on the land.
Right.
And it's the planning permission is to station the houseboat on the land, not to station the caravan. And I go back to the point that I've already made, that if you were to take the caravan off the float, you couldn't station it on the land pursuant to the permission, because the permission doesn't provide for that. It provides for the houseboat as seen at the time of grant.
Right, well, I think we've probably got that point and flogged it to death.
Sorry, that's
Are there any other points by way of reply?
And just, if you bear with me a moment. Sorry, just gonna check. Just on the I'm your man Winchester point that was raised, it is important that I'm your man remains good law. There's a distinction between what amounts to a limitation in the description of development, which you can't have, and what amounts to a matter of functional significance, if you like. So I give the example: if you have a planning permission for a shop, a retail unit of some description, you can have in the description of development something that describes the nature of that shop, because you have different types of shop. But you can't have something in the description of development that defines when that shop can open, because that's a limitation. That has to be by way of condition, and that's the distinction between Winchester and I'm your man. It's I'm your man shouldn't be set aside in any way. There are other certificates on the site, across the site, as my own friend said, 11 by 2014. But as I pointed out at the beginning of the day, there's a number of different planning permissions relating to different structures, if I can put it that way, on the site. Not all of the structures are Willoughby caravans on floats. So great care needs to be taken in considering the relevance, if anything, of the other certificates. They're all very fact specific, dependent on what the permissions were in the first place.
Well, I think Mr. Cottle accepted that the certificates were likely to be fact specific.
My very friend, in terms of the effect of the certificate, said that the description in the 1998 permission is no longer operative. The difficulty with that approach is there has to be something provided for by the 2014 certificate. And it just says certificate of lawful use as existing for occupation as a sole residence. Now that, with respect, is meaningless without context. And the context is in the reasons it talks about the accommodation. In the first schedule it talks about as existing, and we know that this certificate relates to houseboat 8, as was granted planning permission. So the certificate can only relate to the accommodation, which is the houseboat at 8 West Pontoon. So it's not right to say that the description of elements is no longer operative. It is operative in terms of how the 2014 certificate is interpreted, whether it be by way of the certificate being a breach of condition certificate or a certificate being a change of use certificate. Because the change of use is a change of manner of the use, if that's what it is, if that's what the certificate is. It's a change of the manner of the use of the structure, not the structure itself. So it still must have application. Otherwise, we're left with a certificate that really, it's entirely unclear what it provides for. I don't think I can assist you on any other points.
Well, thank you very much, Mr. Rudd. Thank you very much, Mr. Cottle. Thank you, obviously, to all those who sit behind you. It's not just all the work of council, so thank you very much to solicitors and those directly instructing. We'll reserve our judgments. It's not the most straightforward of cases. We'll try and get them to you as soon as we can. Hand down remotely in the usual way, there's no need to attend. We'll circulate our judgments in draft for any typing errors or obvious factual errors and the like, but not obviously for re-argument. We would very much like council to try and agree an order, if possible, in the time that we give you to consider the drafts. If you can't agree, then some short written submissions. Any consequentials, likewise, by the deadline that we'll give you. If you need more time, please let us know well in advance. Personally, I just don't like handing down a judgment without doing the order at the same time, because it makes it tidier, particularly if anybody wants to take the matter further. So thank you very much, and thank you to the only other thing I need to say, and I don't need really to remind either of you about this, of course any drafts will remain confidential and will only be capable of being circulated to those on the list, which will be provided to my clerk, please. And I don't really need to remind you how strict the embargo is, but we are always exhorted to remind everybody about that. Thank you.
All rise in favour.